In this video, we are going to talk about whether you should wait until your parent becomes a US citizen before he or she files for you. If you're an adult who have overstayed in the US, the first question you ask is, well, will it be easier and faster if a US citizen parent files versus a green card holder parent filing? And then also, will I be able to adjust my status so that I wouldn't have to go back to my home country for a visa interview? Before I get to that, please visit us at Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to the channel. Let's have a chat about this process because it can be very tricky and confusing for many people. So, is it really better for a US citizen parent to file for an adult child who have overstayed in the US? Now, when I say adult child, I mean someone who is 21 years of age or older. You may have your green card holder mom or dad, and you are just waiting until maybe they reach the point where they could naturalize and become a citizen, or if they have had their green card for a really long time. You are trying to convince them to hurry up and file for citizenship so that you can start your process. Whether your parent becomes a US citizen or not does not change the fact, or it will not change the fact that you are still not going to be considered an immediate relative of a US citizen. Immediate relative of a US citizen are individuals who are children under 21 and unmarried. They are also parents of US citizens and spouses of a US citizen. That's it, guys. Just those three groups are considered immediate relative. If you are here, the United States, and you are out of status, or you've also worked without authorization, you are still going to face the same consequences as others in a similar situation, meaning that you are going to need a waiver at some point in order to get through and finish this process and have the green card in your hands. Also, you are going to be in the family preference category. No matter if your parents are US citizens, you are still going to be in the family preference system. If your parent is a green card holder, LPR, you are going to be in the family system, which means that you will have to wait. The visa is not going to be immediately available to you as it would to an immediate relative of a US citizen. Now, the question is, well, will it be easier and faster if a US citizen parent filed for me? You are still going to need a waiver. The waiver that I mentioned earlier because of unlawful presence. Again, this video is for those of you who had or have overstayed in America. So you have unlawful presence on your record, and you will need a waiver to deal with a bar to your re-entry. If you were to leave America, you're going to be barred for either 3 years or 10 years from returning. And so to get over that issue, you're going to need a waiver before you leave America, of course. You will still need to also cancel process, go to a US embassy foreign immigrant visa interview again. This is all under a US citizen parent. You have to do all these things. The other thing I want you to consider is the visa bulletin. There are two tables on the visa bulletin that you should pay very close attention to. The first is table A, which is the final action table, which shows green card applicants have priority dates that are current and ready for adjudication, whereas table B, dates for filing, which means those of you who are here in the United States, you can now apply for adjustment of status based on the dates on this table. And those of you who are abroad, you can submit your documents to the National Visa Center. And again, just a reminder that green cards will not be approved until the priority date is current under Chart A or Table A. For F1 category, we see that the government is up to the adjudication date of December 1st, 2014. Now, if you jump down a little bit to F2B category, which is the category for adult children of green card holders, we see that they are adjudicating those cases a little bit faster. They are up to September 2015. So that's really important to keep in mind here. The F2B category is actually moving a little faster than the F1 category. Is it better to be in F1 versus F2B? Not really, particularly with respect to the speed of adjudication of the application before the government. People usually ask, well, if I'm here in the US already, I'm an adult, I'm over 21, and my parent has filed for me, can I now do adjustment of status? Well, you may have heard me say before that, firstly, You cannot do adjustment of status if a visa is not immediately available to you, meaning your priority date is not current yet and you have not maintained a lawful status. You must be able to show that you've continuously maintained a lawful status in order to be eligible for adjustment of status. You have maintained that lawful status. Let's say you are here on F1 student visa. You are still enrolled in school. You can plan to continue your education for the next several years or however long your application is pending for the green card. Then, yeah, you can actually adjust your status when your date comes up, when the priority date becomes current. Just to summarize, it is faster, easier, better to wait until your parent becomes a US citizen to start the process for you. My answer is actually no. Start now. Start when your parent is a green card holder. Get into the queue. It's going to be a lengthy wait anyway, at least 5 or 6 years before your priority date becomes current. So get in line and don't wait, because there's really no true advantage for you waiting until your parent becomes a US citizen. I hope you found this video helpful to you. Please share this information with family and friends who may need it. You can also help us spread the message by sharing it on all social media. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!